Another way, if you just want to provide some anonymity for your personal residence, I mean, we do tell you to put it in your living trust. That's where it should go. But if you just want to have anonymity, because your living trust will have your name on it. Okay, Dominic and Danielle, your name will be on your living trust. My name's on my living trust. So if you transfer your personal residence into your living trust, people still know that it's in your name. It's an asset that they can bind. But if you set up a land trust and you call this trust the XYZ Trust and put your personal residence in the XYZ Trust, then it's out of your name, and then you put this beneficial interest into your living trust, and it goes inside of there. Now you have some anonymity for your personal residence, so they don't see the fact that you're on title any longer. Now remember, it's just a land trust, so there's no protection really there for your personal residence, but it just provides some anonymity. As you can see here, though, that if you ever buy property in one of those states that you decide to treat as your personal residence, because they have such high homestead exemptions, I would not recommend you utilize that strategy, because you never want to jeopardize an unlimited homestead exemption. And you know, Washington's not a big deal, but you know, Florida, of course, we know people have moved down there to get away from a glove. What happens when you set up the land trust, you actually deed the property, okay, from your name into the name of the trust. So here we go. If I own title of the property and I use the grantor's name trust, Woodlawn Trust, okay? So if I created the Woodlawn Trust, then title would go from Clint Coons to the Woodlawn Trust, okay, with so-and-so as trustee. So when you look up County Recorder's database, say for Pierce County, there's a deed that gets recorded in the name of the trust from my name as a grantor, trust as a grantee. So this is what they see now, this guy right here. So why do we go through this whole process of taking property, transferring it into a land trust, having a trustee resign, you get listed again as a trustee, and then you're the beneficiary of this trust? Why do we go through this complicated process for people? Is it to engage solely in these types of transactions subject to? Not at all. I tell you, I don't recommend you do subject to or engage in subject to transactions. It's back to boxes again. Here's an LLC. You could, yep. This is my property. My property has a mortgage on it that says that if I transfer title to real estate, the bank has the right to accelerate the mortgage. So if I do this, create an LLC, drop it in here, close it up, and the bank finds out about it, they can accelerate the mortgage on this and I have to refinance the property. So, do I want the bank to know that I've moved property from my name into the LLCs for asset protection? If they're going to do that, probably not. I mean, the ideal situation would be to go down to your bank and say, listen, bankers, I'm going to create some boxes and I'm going to put my properties into them. Because if I have several properties and I've divided them up into separate boxes, you're in a better financial position. Because should anything happen in this box, the properties over here are protected, and your financial position in this box will not be affected by what happens over here in this box. Because right now, I own everything in my name. And if it's all in my name, whatever happens to me could impact all these properties. Say this one goes under. It's getting foreclosed on, and they seek a deficiency judgment against me. They get the cash from these over here. Now you're stuck in foreclosure on these properties. Do you want to be in a foreclosure bank? No. So I'm trying to help you out. And what do they say to that? No, you can't do it. Why? Because that's our policy. Well, explain to me how your policy works, because if you're a banker from a financial standpoint, your idea is to eliminate risk, not increase risk. No, not even going to address that. So what people do is they will then create a land trust. Say, okay, fine. If you see this transfer into here, you want to call my note due, I'm going to put it into a trust, which is a grantor trust. And if it's a grantor trust, then, okay, it falls under the Garn-St. Germain Act. It allows us to move the property into the LLC. Because under the Garn-St. Germain Act, we're protected from the due on sale clause. They assume that you've created this for estate planning purposes. Now, you transfer the property from your name into this trust. Everybody with me on that? Now this trust, can I transfer it to Rod? We already discussed that, right? I can transfer the trust. Yeah, so what do I do with it? Put it in the box. Now, if anything happens inside of the trust, it happens in my box. Does the bank know that it's held by the box? Not at all. Unless you ring, ring, ring. Hey, bank, I move property into a trust and I put the trust in a box. What do you think about that? Yeah. Have people done that before? Yes. And I've asked them, why did you do that? I forgot you told me not to, Clint. Okay? Don't ask permission, right? Always ask for what? Forgiveness. You learned that when you were 2. Okay? Don't forget those life lessons. Because if you call your bank up, they may even say something else to you. Oh, we will allow you to transfer your title into a trust, but you may not be aware of this, but if you look at clause 13, it says that we have a title transfer fee equal to 2% of the outstanding mortgage balance. Yeah. Some banks do that. They have a title transfer fee now. They don't have to do anything, but they just want to nick you for extra money. It's bogus. So, this is what many people do to get property into their LLC without alerting the bank to the fact there's been a transfer of real estate from their name into this company. They use this intervening step here. Many people do that. I have never used this, and I will never use this transaction personally. Why? Because look at how many, I have 2 entities here now in order to put this property into there. I think that's ridiculous. I just like to go, as long as I'm paying the mortgage, do the banks want to own property or get money? Yeah, especially in this climate. How many of them are concerned about mortgages that are defaulting versus mortgages that are paid up to date? You think they're going to go look around and say, oh, wait, he transferred real estate and that mortgage, even though it's performing, we want another bad loan on our books? Not at all. I've asked this question for 11 years. Does anybody know of a situation where somebody has transferred title to real estate into an LLC and the bank called the note due? Has anybody in here ever heard of that happening before occurring? It happened to you? Okay. 2 people have answered affirmatively, yes. Okay? Now maybe you can figure this one out because they couldn't. They said, oh, you can't do that. They'll call the note due. And I said, really? He said, yeah. I go, well, what happened? One person said, well, I was late on the mortgage 1 month, and then they called it due because of the transfer. You think that's why they called it due, because of the transfer? Had nothing to do with the fact that you're late on the mortgage? And another person hadn't paid their insurance, didn't have current insurance on the property. So what do you think that tells the bank? Hey, we got a problem here. You've just given them a way in which they can call your note due by transferring it in. But as long as you're paying the mortgage, you got your insurance, it's never been an issue for me. I mean, I've yet to have a bank send back one of my mortgage checks and say, you know, you took the loan out under your name, Clint, and we received a check from XYZ LLC. We won't accept the money drawn on that account. We only accept money drawn on your account. No, it never happens. So this is why people will use land trusts. And if you feel uncomfortable with making a direct transfer, which some people do, they just can't sleep well at night thinking that, oh gosh, that phone when it rings, could that be the bank calling and saying they want to call in the note? If you fall within that category, we got a solution for you. That's why we say every time you set up an LLC, if you want a land trust, we'll throw in a land trust for you, we'll set it up for you and put it all together like this. If that makes you sleep better at night. Doesn't matter to us how you want to set it up, because the LLC is what provides the asset protection. How we get it there is up to you on that transaction. But I mean, my preference is just to go directly in the LLC. I like to keep things as simple as possible, the fewest entities as possible in my structures to maintain the amount of asset protection I feel comfortable with.